Good morning, good afternoon, good night, whatever time it is, wherever and whenever you are. This week we're going to be exploring intellectual property law considerations of AI, big data and blockchain. It's a really interesting week, I think, and essentially where we're going to start is I'll make a couple of short videos explaining what intellectual property law is and looking in particular at what copyright and patents are before we do a deeper dive into applying these legal concepts to the technologies that we're interested in. Now, the first couple of lectures in particular are designed for students who have not completed intellectual property law as a course. So it's really focused at the business students and those law students who haven't done the deep dive. If you've done the deep dive, you will find this very high level, but it hopefully will be a very useful refresher. So let's start by asking ourselves the threshold question. What is intellectual property law? I remember when I was studying IP law back in the 1980s, such a long time ago, my father once saw a textbook that I was working with. Remember those physical books? Anyway, and he's like, oh, that's just ridiculous. People can't own ideas. And he's a very smart man. That is actually true. Intellectual property law basically refers to creations of the mind. So inventions, literary and artistic works, designs, symbols, names, images, all of the kinds of things that we use in trade or commerce to give a form to the ideas that we have. Intellectual property is the copyright, the trademark. It's not the idea itself. And intellectual property law intellectual property itself is protected by law through patents, copyrights, trademarks, and a range of other legal mechanisms. I'll give you a high-level list in a second. And essentially, these mechanisms allow people to earn recognition and to reap the financial benefits from their inventions or their creations. So not the underlying idea, but the manifestation of that idea in some way. So we're going to focus on copyright and to a lesser extent patents. But it is important that we think about trademarks as well, and to think about the ways that intellectual property, the range of different intellectual property sources can be critical to the ways that our businesses operate. Intellectual property provides a competitive edge. It can foster innovation and provides a significant source of revenue because intellectual property rights can be licensed or sold. So understanding what intellectual property is and when it obtains protections is really important for business students in particular, because it's going to be important for you to recognize when legal considerations need to be taken into effect, because if you fail to meet the legal requirements, you can really lose out on significant revenues and capital growth in your businesses. And intellectual property is more and more a strategic imperative particularly for technology businesses, which I know many of you are interested in. So the slide here shows a range of different types of intellectual property that can be protected under Australian law. Each type of intellectual property has a set of primary sources of law in Australia, and in addition to the legislation that's on the slide there are also additional regulations. Of course, there is case law, and there are also international treaties that impact the protection and enforcement of these intellectual property rights. As I mentioned, we're going to focus on patents and copyright over the next couple of short lectures, but I do want you to think about trademarks. So what is a trademark? A registered trademark gives its owner the exclusive right to use a particular mark in connection with goods or services that mark covers. So it prevents others from using similar marks that could confuse customers or that could hold out somebody else as having some sort of ownership or connection with the goods. To be registrable, a trademark needs to be distinctive and capable of distinguishing goods or services for the business. So generic terms or overly descriptive marks are not usually eligible for registration. A really good example of this is the word apple would never have been able to be registered in connection with a type of fruit or vegetable, particularly a type of apple. But it was available for registration in relation to computer electronics because nobody at the time was associating computers and electronics with that particular name. Trademarks are closely linked to goodwill, which is why I'm mentioning them now, because we've talked about goodwill a number of times in these recorded lectures. So goodwill, as you'll remember, is about the reputation, the customer loyalty, and brand recognition that a business builds over time. Goodwill is the value of that, and it represents an intangible value of a business. Trademarks often serve as a symbol of that goodwill in the market. And because trademarks, when they're done well, encapsulate a business's identity and reputation, when customers see the trademark, they associate with the quality or the trustworthiness of the products or services and their expectations from that brand. The value of a trademark increases goodwill when it is valuable. So goodwill of the business will grow as a consequence of this registration of a mark, which really is a very low cost asset when you think about it. I haven't got a separate video on trademarks. I'm not planning one anyway. We'll talk about them in the tutorials, of course, but I just want you to think about those. There's a broad range of intellectual property rights as well, but we're going to really focus our attention on copyright and patents in particular, because the concepts and the questions that you need to ask should become evident when you work through the materials yourself. But before we do that, let's think about what the policy reasons are behind intellectual property. Let's think about why we have IP laws in the first place. The public policy rationale for intellectual property laws are twofold. Firstly, by granting creators exclusive rights to profit from their inventions or creations, IP laws incentivize innovation and creativity. It costs a lot to develop a new drug or to develop a new technology. So the investment or the risk that businesses take on when they go down that innovative path, they can see the light at the end of the tunnel if they know that they're going to be exclusively able to monetize that particular invention for a period of time. So when it comes to inventions, for example, so a patent over a new drug, for example, the inventors need to disclose their invention to the public and contribute to the collective pool of human knowledge. So essentially, the state is balancing off. On one hand, I'm going to give you exclusive rights to monetize this because you're sharing the secret. An invention doesn't, by making it public, you're sharing it with the world, and then you have a period of time that you can exploit it. So it really comes down to answering that question of can you own an idea? The question my dad asked me all those years ago. The public policy idea, as we've just discussed, is about incentivizing innovation and creativity and facilitating the sharing of knowledge. So the short answer is that the ideas themselves are not protected under intellectual property law. Instead, it's the expression or the manifestation of the idea that can be owned or protected. So emerging technologies, so AI in particular, present new challenges to traditional intellectual property law. Generative AI can, it seems, create novel content, including designs, even music or text, raising questions about whether those creations can be owned, and if they can, by whom. Current laws tend to require human authorship or inventorship, complicating the issue of ultimately, is a prompt enough? Who owns those generated works? So ultimately, intellectual property law at the moment doesn't grant ownership of ideas, but it protects their expression once they're manifested or put in tangible forms. But it protects it provided that the requirements of the legislation are met, and at the moment, that requires a human inventor or author or performer of some kind. So what you're going to find on Canvas is quite a lot of content as usual, and I want you to be clear on what you're going to see. We're going to cover the basics of intellectual property well, that's what I've tried to do in this particular video. And in future videos, we're going to look at copyright and patent, but the materials on Canvas are really focused on copyright. We're going to explore some challenges on Canvas in relation to new technologies, and we're going to think about what this means for the future of the use of AI-generated inventions and artistic works. There's some really great case studies on Canvas, and I'd really encourage you to have a look at them. Particularly, I know some of you are interested in the future of the music industry. Clearly, free speech is a really interesting area here, and also NFTs, so blockchain artworks. Now, clearly, this is also important because it helps us with our second assignment as well. And so thinking about the intellectual property issues and the ways that your business needs to make the most of the protections that are available to it will be really key to moving forward. So in the next video, I'm going to talk a little bit more about copyright.